Imobi bi akwaba eba Melodies TV so. Now the game is on. Gyakye Quayson through the lawyer Tsatsu Tsikata a file ewo Court of Appeal over sa everyday trial now you say Gyakye Quayson wombrano. For those who don't understand what's going on, Yawahana yebe katre Gyakye Quayson say umbra court every single day. Some of us we spoke against it because we felt say it was a way to sabotage him. Why wouldn't him? The history between Gyakye Quayson and the judiciary. Case where one of the cases are ama judiciary no omudin asay ewo Ghana pan how Gyakye Quayson was treated. Yamana unko parliament later ye babe eyi ne free ho ye ka say yin deleting the record. And there was answer akwako winning, but answer no be winning no. Some people were also trying. I mean, the state prosecutors, right, state attorney general, were also trying to use the court to prevent him from campaigning. It's in a lawyer Tsatsu Tsikata echo file for review of that decision. No? At the end of the day, judge ni ruling our deba and say, okay, Gyakye Quayson embra after watu abanewie, but ombra daily trial no. Inti yatu abanewie Gyakye Quayson e wini. And then ne lawyers Tsatsu Tsikata nso tre say yenso ye the assembly court appeals court say sa daily trial na ye say Gyakye Quayson wombra court every single day no entwa ye yenko kenkan de ntia worker say entwa ye no. And then I'll do a small analysis on this and probably what might happen. Okay, now we'll say notice of interlocutory criminal appeal rule 59A of CI 19 of 1997 as amended by CI 25 of 1999. Okay, also please take notice that the accused person, applicant, appellant, hearing, who is dissatisfied with the decision of the High Court, Criminal Division 3, Accra, presided over by Her Ladyship Mary M.E. Yanzu, dated the 23rd of June 2023, hereby appeals to the Court of Appeal on the grounds set out in paragraph 3 and will at the hearing of the appeal seek the relief set out in paragraph 4. As a part of the decision complained of the refusal of the court below to review and or vary its decision of the 16th June 2023 at the behest of the Attorney General, ordering day-to-day hearing of the trial and fixing 20th to 23rd June 2023 for continuation of the trial. I say 3. Ground of appeal. The court below erred in law when it failed to appreciate that the exercise of its discretion on 16 June 2023 in respect of the grant of adjournment violated the provisions of Article 296A and B of the 1992 Constitution, as did the exercise of prosecutorial discretion by the Attorney General. To say, Gyakye Quayson ruling na judge the man, no judge no ye mistake. Na mistake na we quote article I watch say based on article Ghana Mra article say ni article 296A ninti no judge no ye mistake. Ruling na we can say Gyakye Quayson wombra day to day no. Inter of the Court of Appeal. We see particulars of error of law. Just we betray mu baby a judge no ye mistake nangasa. Also the court below's invocation of the trial law that adjournments are a matter of the discretion of the trial courts made it oblivious to the requirement of Article 296 of the Constitution, which requires that every such discretion be exercised fairly, candidly, and devoid of arbitrariness and capriciousness, and not biased either by resentment, prejudice, or personal dislike. Now, say adjournment, say judge adjourn case, can say, oh, yamani bakonemra every single day, no. Yes. Oshe Attorney General, defense, what they call court against Gyakye Quayson now say, judge, embrama kwine. Say time be our person or adjourn case be no, adjourn case no. And Tsatsu Tsikata say, yes, embra emma judge ne kwine, say o adjourn case no. Now so embra ne say, judge no adjourn case na, ma enye biased. Ma enye say adjournment no, ebe bu obi, embu obi. Ma enye se ade no adwembo ni bi techi na de aye. Na wo hwe nipa kra wo propose sa day to day adjournment ne kra na em say e attorney general no ne propose tre judge no nti Gyakye Tsikata atre say enya judge na adwen e na ka say yemfa nye adjournment no na Gyakye Quayson mbra every single day. It was first mentioned by the state attorney or the attorney general, and then the judge also held on to that. Inti enya judge no na adwen e no de yes. I hope you understand what's going on. Inti no let's move to the second slide. Or see, the court below failed to give due attention to important considerations such as constitutional rights of the accused in exercising its discretion. Court no ewie no one fa ebuo amma Gyakye Quayson no ne constitutional rights. Inti yes, ebia wo be agene case every single day and now wo ma adjournment also making sure say nipa kro ne right, constitutional right. Obey every single day. If you are not every single day, I will ageni case no. Etia ne pakrono ne fan hu die bi so. It is a de na court no aye no entwaye. It is part of the error. Tsatsu Tsikata e claiming. Now, we say the court below erred in law when it claimed that matters brought to its attention by the accused regarding the abuse of prosecutorial powers with extremely prejudicial implications and an insult of the accused person and professional misconduct by the Attorney General in respect of this case were not relevant to its consideration of the review application. One say, answer na womo be call court no. And now womo call court the first time, answer na yebema ruling no. Na Attorney General semo a woka ene ane Gyakye Quayson waye bone and yebe china to me yebe prejudicial no tre say or the bar court through the review say a prejudicial say the state attorney no ebeka sansem wenti eni kwan say ye pene ema sa day to day no ye adwuma no judge no ka say dabi enye prejudicial nti ende in filing at the appeals court and filing the appeal no Tsatsu Tsikata tre say eye bone it was still an error judge no eye now this is the particulars of that error. Also, prejudicial statements made by the prosecutor, the Attorney General, seriously affect the fairness of the trial. It was the error, let's say. Ghana mratre say, obi di bone krana, e was a wo tre, e wo court answer. It is Attorney General, they would din kind no one, am no can't say ni bakrono, and they would di bone ye betchina, e prejudicial. It seriously affects the fairness of the trial. It is judge no rule in our mind, no. Judge no mistake. Also, the court below completely abdicated its constitutional obligation under Articles 12 and 23 of the 1992 Constitution to ensure that administrative officials carry out the duties reasonably. Also, the court below also abdicated its inherent powers to ensure that its officers conduct themselves in accordance with the standards required of them under the rules of professional conduct and etiquette. Into what say? Court no embra wo court say lawyer bi obeba begina court no wo so odi embra so embra ni bi ene say you will not be prejudicial. That's why I think this is going, because what about etiquette any conduct no, that's why I think this is going right. Also, the issue of professional misconduct by the Attorney General, which were brought to the attention of the court below by the accused person, appellant, were additional reasons for the court to have reviewed the decision it made at the behest of the Attorney General for day-to-day hearings, and the court had on 21st June 2023, at the hearing of the application for review, ruled that the supplementary affidavit, which provided further evidence on these allegations, was relevant and admitted the said affidavit is evidence on that ground, but now changed its position with no legal basis. Also, the court below erred in law when it failed to appreciate the significance of the rights of the accused person contained in Articles 19.13 and 21.3, as well as Articles 19.1 in respect of the necessity for a court, when exercising its discretion, to consider all relevant factors. As a particular of error of law, The constitutional provisions refer to establish important constitutional rights which must be enforced rather than being curtailed as the decision of the court did. Yeah, so that's why I was saying the court below erred in law when it invoked section 169 of the Criminal Procedure Code as if that section requires or justifies a criminal trial being heard day to day. I say particulars of error of law. The terms of the section regarding grant of adjournment make no reference to day-to-day hearings of a trial. So shall tremu rulings a court my and the day-to-day court penny so no nina a yentro I mean in and yes a yentro but nina and try court no a error because so share Ghana mbra articles be a quote in na and faso and in this was a court or yes anyama na wo no. I said the court below erred in law when it failed to appreciate that on 16th June 2023, it did not have jurisdiction to hear and determine the oral application made by the Attorney General without prior notice to the accused and his lawyers for a significant change in respect of the fixing of date for hearing of the case. That is say embre by Osha DC na court no error. And the court didn't appreciate. Say 16th June embre mo call court no. Na court no ni kwan say what say wotie case no without informing Gyakye Quayson. Now so court no wotie case no em say without informing Gyakye Quayson. As the particulars of error of law, the court below did not address the issue raised in the application for review that it did not have before it on 16th June 2023 any application or notice by the Attorney General to the accused and his counsel concerning the fixing of hearing dates for the trial day to day, and the court below acted in violation of due process of law, thereby contravening Article 296B of the 1992 Constitution. So the decision of the High Court was per incorium a binding decision of the Supreme Court in Republic versus High Court, Commercial Division A, Temale, ex parte Kalim, 2015 to 2016, SCGLR 1332, and therefore in violation of Article 1294 of the 1992 Constitution. Particulars of error of law. The said decision of the Supreme Court makes it clear that it is within the inherent jurisdiction of every court to review, vary, or modify orders it has made in circumstances such as those brought to the attention of the trial court in the application for review. Relief sought from the Court of Appeal. Reversal of the ruling of the court below dated 23 June 2023. I almost from Court of Appeal now say one ma in share High Court no share say Gyakye Quayson one bra day to day no yembongu. Yenka say Gyakye Quayson case no yembo case ni nangu dabi. But day to day say they be a one bra no yembongu. Yemfre case no nanso enye so obeba de bia. Person most directly affected by the appeal, the Republic respondents, okay. I say address of the appellant into Gyakye Quayson the address and address ebo ho a eda ho into no no nsem ni na any. Now, I think say this is a legal battle at play. Okay, I believe that I believe that now what the legal team of Gyakye Quayson would like to do is try as much as possible to delay the court case. If they are able to try as much as possible to delay, because now no MPP will be banking on the hope say yenche Gyakye Quayson into ne achi ni tumu a ye be by election na ebi omo asanso nya another chance. And you know, for the NDC, I feel say what they also want to be doing now is to delay the process. Into a delay process, and me and say next year you to aba na NDC ba case way better than a foolish case. And so for them, they will be looking to be delaying this process as long as possible. Once again, the yana criminal cases ba yana ye use 2 years 3 years ni edidi but Gyakye Quayson no because ye pese ye by election ye chini tum ne by election nti obo pese omo ye ne ntentem NDC fo nso pese dabi ye nko ne se ne ye ne enim ze ye ko ne wo Ghana na because ye ko ne saa obewie na okọ ana ye wie na okọ a attorney general no ebesesa obe discontinue case no na asem de na asem ko nti no eno no mo ntwe mo comment box ni mo me da ase